Uh, so today we'll be discussing on the last time we will be discussing on the case disciplinary orders. I have taken last time I had prepared for four orders. We could only complete two of them as we go in detail. So this time we will complete. We will try to take it forward, and if possible, complete two of the balance orders. Further, yesterday there was one email received from one group of companies stating that what are the analysis of the various last 5, 6 years, 200 orders which have come. So we can also take this after the first decision. This is of 7th May 2026 in the case of Shankar Iyer. In this case, what has happened is there is always a delay in submitting of the annual this quarterly progress report and other papers and extension and this exclusion application. That is the main crux of this issue. The order in the matter of liquidation has not completed in specific. The Honorable Court, by this order, directed that the period from the state. See, during the COVID period, there was a order by which the Supreme Court had excluded a long period of time due to COVID. But that did not suggest that in every case it has become an automatic exclusion. One had to apply for the exclusion and then obtain in all the matters. So in this case, the period of 1 year was the period was over. He did not seek the extension or extension. He sought an extension after a very long period. You see the extension of liquidation period of by 673 days from revised expiry of liquidation period. The said application was filed after more than 450 days from the expiry of the liquidation period. See, these are the small points we at time ignore, and then we land ourselves into the problem. That is the main crux of this case, which is to be highlighted that it is the basic duty of the RP to see that applications are made in time. But at times I have seen that when we suggest to the COC that we need to apply for the extension, they take a casual approach. नहीं अभी रहने दो, next time देख लेंगे. And then we should record that properly in the minutes of the meeting. Otherwise, what happened that we have sought the extension and COC said no, that we will defer the agenda and that recording should be helpful. Sometimes, at times, what happened when the resolution is passed, it is put on voting, and voting normally takes to 20 to 25 days. And that 25 days, 30 days is additionally lost. Further, when we give it our papers to the lawyer, with due respect to lawyers all, at times it takes 15, 20 days to prepare the application and file the application. So all that time is to be properly recorded so that we are able to face the disciplinary order. That was my message. Here, see what has happened. We find that the act of liquidator is completely careless and he did not bother to make an extension application for the liquidation period within the timeline provided under the rules. The liquidator has been asked to explain the reason for not making the application in the time, but he could not reasonably cause for the delay, offer cause for the delay. Delay in submission of the progress report and non-filing of the liquidation forms. These are the crux of the matter. While form liquidity has not been filed till date, and there was significant delay in submission of 4 to 19 quarterly progress report. In response to board, Shivaguma submitted that as per his understanding, progress report beyond the third report could be filed only after obtaining an extension. These are the reasons which he has given, but it was all not accepted. Shankar Iyer admitted the delay and errors occurred into an incorrect interpretation as he was waiting for the order pertaining to the exclusion for the COVID period. The apology is the same and submitted that he would that have not caused hardship to the creditor is made utmost effort and yielded better distribution to the creditors. All these reasons were not accepted, and ultimately, see, he was under thinking that unless the avoidance application is been settled off, pendency does not impact the complete of liquidation period. In this relation, liquidation process commenced prior to the commencement of the Insolvency Bankruptcy Board of India Liquidation Process Amendment Regulation. The requirement of regulation has existed before such commencement and duly apply. Thus, the liquidation process runs distinctly from the avoidance application. Its pendency does not impact the completion of liquidation and dissolution of CD. See, the type of delays which has been 9/3/19/4/21. These are the different dates for the progress report where there has been delay. In one of the cases, I had a typical case that at the year end, we need to certify the cash flow statement, which the approval of the SSC members was not taken for appointment of the chartered accountant firm for cash flow certification. And then subsequently, when the details of expenditure were given, the SEC member raised the point that you have not obtained the approval for that. So I said it was required for the same and progress report. So it was done in a hurriedly manner. But the same SEC members, when they wanted some report urgently and to engage a professional firm of chartered accountant, they are saying that no, no, you take the report, but pay the fees and take the subsequently ratification. Well, the last time when I paid a small amount, you raised an objection. Now you want to make me a payment of much larger amount and without approval. You put a mail accordingly. In this case, the year the registration was suspended, registration of suspended for a period of 3 months. Not a grave punishment, but this is the case. Why I took up this case was that sometimes we take a casual approach and we ignore the requirement. But or sometimes what happens, at times what happens, our staff managing the same is on leave or he has resigned or other cases, and we don't give importance to the small formalities, but sometimes the small formalities of procedure hamper us in a big way. Anything on this?
If you see, Pravinji, Shantanu here,
Yes, sir.
if you see our IBBI in this case, of course, 3 months suspension he kiya, but of late, I mean, if I have been also reading all these orders, typically I do not know what can be let off with a warning or a fine. Why do they have to suspend? You know, this was a fit case of fine, probably some kind of a penalty. There was a genuine misreading of the law or whatever regulation by this person, but they've still gone ahead and you know
Suspended the.
suspended the license, and
Yes.
that becomes a permanent blot on his career of sorts. So uh,
In
somewhere
suspension,
down,
what other difficulty happens is that if you are handling four cases, if you are
ah,
suspended in one of them because of one of the fault, the other
hmm,
three also goes away.
that's right. If the suspension of the license happens.
Yes.
So, with somewhere, I think as the RPs or some RP body, we need to probably make a representation to the highest level of IBBI that भाई whatever procedural lapses के लिए आप फाइन लगा दीजिए, बट सस्पेंड तो नहीं करना चाहिए, बिकॉज
Yes.
इसमें कोई मॉरल टर्पिट्यूड तो दिखता नहीं है इस पूरे ऑर्डर में कि कुछ मैलेफाइड इंटेंशन से उसने किया,
Hmm.
जेन्युइनली कुछ मिसरीडिंग हो गई, एंड दिस सो आई डोंट नो, आई डोंट नो. Maybe the
In
other
his
RPs
case,
could also.
yes, he had said that there it has not caused any loss to anybody, but that
Yes,
reason
yes.
was not accepted.
It is
Yes, sir,
not.
Ganti sir.
Actually, while on the face of it, it appears that suspension is a harsher punishment and a fine would adequately serve the purpose. In practice, it is the opposite. Okay, all that the suspension that they do, they usually the order says that they don't remove the RP from any assignment. They prevent the IP from taking fresh assignment during that period, which most of the time would not cause any pecuniary harm to the IP. Okay, and no fine means there is no damage. So it is a suspension which is of a pro forma nature most of the time. Sometimes it can. So and this is what IBB has found out that they send a message without causing any damage. A fine actually causes damage. Okay, it depends how much then, and would it be from time to time. So, like they say, sometimes the conventional wisdom does not tell you what is the right, outcome of an action. So I've been observing this from long time, and all that they write in the order at the end is that just send it, inform all the other assignments where the IP is also acting as an RP or something, and it is for the COCs of those particular cities to take consider what they want to do. Most of the time, they do nothing because once the item matter is explained to them, they know it is a procedural thing. So most of the time, the harm is not done. So actually speaking, registration suspension obviously is a higher level of punishment. A suspension of the AFA would be a better one, which basically prevents you from taking fresh assignment during that period.
Yeah, so in this case, the registration was suspended. Na? So then to, that person's existing cases will also have to be given up.
No,
No?
they don't. They don't. That doesn't. That's not how it works. I mean, that's not how IBBA looks at it. They say registration suspension. Really speaking, it is like an AFA. Does so you have to read it what is said at the end. Suspended and then what? There is almost always another.
In this
Uh,
case, क्या लिखा है?
एकदम बॉटम में
Swami
देखो.
जी,
क्या
क्या लिखा है?
Copy of the order of the so and so, a copy that is the normal thing
नहीं
which
नहीं, ये
appears.
देखिए किस
yeah,
में
yeah.
लिखा
Hereby suspended the registration of Sri Shankar Iyer for a
For a
period of 3 months.
hmm. See,
है. एक
you see
और.
3.4. They leave it to the
Okay.
COC to decide. And this is a
हाँ,
standard clause now, at least last 5-6 years से तो यही clause है.
Sir,
And
and about
a new thing
continuation of
is emerging.
care.
Mr. Narendra Sharma was suspended, was removed by the IBBI itself.
who?
Mr. Narendra Kumar Sharma.
There is possibility. Every case is not identical. Na? I'm talking of the majority of cases where it is due to procedural lapse and no accusation or allegation of probity, propriety, or any such serious thing. Any suspension, they don't do anything beyond that. Effectively, that means that during that period, you cannot bid for or take any new assignment.
So that is for the period of 3 months. So that period passes away.
Yes, I mean that is it. It
Sir,
is. It is.
what about 3 years?
The 3 years is different. That is a serious allegation. So 3 months wala or 3 years wala, to it is like any other
Sir, देखो
suspension,
कई
no?
orders में देखा गया है जो misconduct ये sorry violation है they are not very serious but still they are removed.
It is like IBBI in this function of disciplinary is like is a quasi judicial function. Can you go and ask the क्या बोलता है, the court, why did you do this? You can only appeal to a higher forum. And that's what people who are affected will do. And they have been doing. And they have been getting stay orders also. Na? See, that way, we cannot question everybody. There has to be somebody in authority. The RP himself is an authority in the CRP proceeding for many cases. तो आरपी ऐसे कर सकता है क्या बोल सकते हैं क्या? नो, देर इज अ प्रोसेस एंड देर इज एन अपील.
We move to the next. Any further
Sir,
question?
yes, sir. One specific question, sir. One retired government employee passed the exam. He is already enrolled as an advocate, but he has some charges with CBI. Charge sheet is yet to be filed. But since for the last 6 months, IBBI is keeping pending for registration. He has disclosed.
No. Okay, let me answer that question.
Please, sir. Thank
There
you,
is a criteria called fit and proper for
yes,
IP.
sir.
Okay.
Yes.
And fit and proper is a judgmental criteria, but it is based on the same terminology and the same criteria used by SEBI for a long time.
Yes, sir.
Okay. Who is a fit and proper person? So, and something similar is there even in the Chartered Accountant Code of Conduct. Okay. So, fit and proper means not only no offense, but even the possibility should not be there at the time of enrollment. So this
Sir,
is, I mean, I can give you the recent example would be Meenakshi Natarajan Rajya Sabha thing. Okay.
yes,
There
sir.
was no charge sheet. There was just a complaint. It had not even an, FIR was lodged, but the nomination was rejected.
Yes, sir.
So this bar at the enrollment stage is very high.
Sir, there is a
Good, bad,
difference.
ugly, that is for that person to fight there. Okay.
Yes, sir. This is accused and convicted. There is a small difference between them. He is accused,
Fit and
but not
proper.
convicted.
Fit. Are you listening?
Yes, sir.
What did I say? Fit and proper has nothing to do with conviction. Even
sir.
the mere allegation could be sufficient to deny enrollment. Enrollment is not a right.
Okay, sir.
Okay?
Thank you.
That is the
Thank you,
law.
sir.
We move to the next point.
Yes, sir.
Yes, sir. Give me 2 minutes. ये फोन देखो ना उसको मैं बाद में फोन कर मीटिंग में है।
কি জল হ্যাঁ হ্যাঁ জলটা প্রথমেই করছি
Mr. Pranapkar, please keep your mic on mute.
I have taken one NCLT, recent NCLT order where just going into the root cause of it, how the bench is now examining that.
While you are looking for the paper, sir, Mr. Navandar, sir, one question that comes to our mind is these are orders. Is like any order sets a precedence for a next order? Are they bound by it, or every order can be at the discretion of the person who is evaluating?
Every order, sometimes they are referring to in this thing or they are referring to NCLT order, but they are not precedents as such.
Not the
Whatever I have
NCLT order.
repeated, see what has happened, this subject has been ignored by myself for last two to 3 years. So I myself thought of, at least studying one or two orders every month. And with that intention, I had taken up this task of opportunity of addressing the members. It
No,
was basically for
no.
the self-study. But members can, Shantanu sir or Ganti sir can say that whether it is those who have been regularly reading this, whether this precedence is noted or not noted.
No, disciplinary orders are based on facts, not points of law. So binding precedence does not apply. Every case is considered unique.
See, one of the next I am taking, what is the level at which now the bench member or the COC members are studying this, or demanding this? In the case of Videocon, actually, I am not the RP here, but I got this order where it has been said that if the properties are lying vacant and if it is not given on rent, or then also that what the COC has been called. See, in the event COC are unable to identify and facilitate prospective tenant, the resolution professional shall consider surrendering the property back to World Trade Center on the value as offered by them by way of an affidavit filed. Here and then next sentence, what the bench member has said, the COC has also called upon to explain why appropriate action should not be initiated against them for failure to take effective steps till date. Accordingly, the register is directed to issue show cause notice to all COC members, and all COC members and resolution professionals are directed to present in person on the next date of hearing. So if something is lying, vacant, at least put up before the COC, okay, how best the asset can be utilized. See, as an RP, what my point is that any asset on any premises which is lying vacant, or at times we find that the funds of the CD are just kept in the current account. And if you are not kept it in the fixed deposit account, so tomorrow the court or the IBBI may question you. This is a limited point which I am like. When you are managing the company, you are supposed to manage in totality. One cannot say that नहीं ये पैसा पड़ा है बैंक में पड़ा है current account में पड़ा है. Especially with the scheme when banks are saying that you put it in our current account and we will give you as an incentive or something. One need to be very, very careful. Any point on this? Or any different type of example? I found that bank FDs, empty premises, all these will apply.
Sir, in this
This is a
empty
recent order.
premises case, this was a liquidation going on or during the COC?
This is which is long litigation case which is in the matter of Videocon Industries.
The issue is how can a RP or COC decide to give it on rent, because ultimately somebody else will either acquire it through a resolution, or if it is liquidation will acquire it. Now, if you were to give something on a rent, what will be the term? What will be
the
the
duration? Term. That will
of
be
the-
the issue. Second thing, if you are given to somebody and if he doesn't vacate on time,
Then
what will
what?
be the consequence?
So this with due respect to this judge, he does pass this kind of orders. This needs to be appealed. How you can take this thing? Like I had one place which I sold during liquidation. Now that was lying vacant. I was getting proposal for good rent, but everybody wanted for 10 years. It was a retail space. How can I give it for 10 years?
nahi.
You
So
know,
as long as that is documented, I think where it comes in is that we do get proposals. So currently I am given on a lease. That person wanted to make some changes to the property. I said no. So it's going on a month on month. Month on month is also acceptable. The principle here is if you're getting 10 years and that is the reason you're not given it, that's good enough reason for you to put it on paper. But as a prudent person, any asset that we have it, if we are owning it, whatever actions we are likely to do should be also be done with the RP in the interest, and any decision that has been taken is recorded. That's a bona fide action. He has attempted, with reasons are cited. I mean, I think that's fair. When we do miss couple of months FDs or something, having current account balance, we do sometimes miss out. But
the
trying to
current
put,
account balance I can understand. Beyond
yeah,
a point, whatever you immediately require for expenditure, rest of it you should put in FD. That part I understand. My this thing remains with the vacant premises, because the kind of cases that I'm having, there are vacant premises. A lot of society dues are up there. Electricity is already cut off. You know, so Now, if you want to go and restore the electricity, the guys will not do it before you pay them the past dues which you can't legally pay. You know?
Any of the current amendment regulations talks about it, right? We have to give an going concern assessment report. That the assessment report itself will say, because this is not happening, I'll not do it. That is anyhow given in the amendment right now. Anything that we do, we have to give an assessment of it. So, with the current amendment in regulations.
Right, okay. Okay. Point taken.
One more thing, sir. Even
In
the
this case, if you see the order, there are in this is the order in the case of Videocon, which I am not handling, and this is the 14 cases, the combined cases which are going on Videocon Industries. In this, there are not less than 12 to 13 COC members, and what is the order says, the COC has been called upon to explain why appropriate action should not be initiated against them for failure to take effective steps till date. This shows that now the IBC code is really matured, or the person who are implementing the code, the bench member, the RPs, the COC members, in last 10 years they have matured. This order would have not been expected in the initial first or second year. But now everybody is vigilant. So one has to be, as an RP or liquidator, one has to be now very, very careful. ये चलता है attitude will not come, and especially when some of the banks have come out of the scheme that you keep the money in the current account and then we one way or other way they compensate. So one has to be really careful about it.
So with due respect, sir, this is from bench to, that's why you are seeing this kind of orders. Honorable bench is particular about it.
Sir, one more.
Can we see the first paragraph,
If you-
please, which is the background of the order?
Sir, if you
Could we not
deposit
see
the
it?
surplus fund FD, you will get interest and also TDS and also required for income tax returns. In especially voluntary liquidation, we have very less time. Again, without getting until you close the bank account, you cannot file liquidation for orders. And if the TDS is there, where will get the refund again? It will be struck. You close the bank account, refund will not come.
But you should not get TDS. Why will you get the TDS? TDS comes to the account.
If you put FD, definitely TDS will come.
No, TDS will be deducted, right? Why should it not be deducted?
Yeah, again, I will claim refund.
But for losing 10% or 2%, 10% TDS, we cannot lose that 90% of interest which is otherwise due to us. Because just because TDS कट रहा है और नहीं मिल रहा है तो 90% in interest which we are getting, that we should not lose.
Yes. It will create problems filing returns. Even if ready to file return, sometimes it's not available income tax returns up to June, July, like that. The return is not available. It will affect the timelines. Okay, it's normal liquidation time, but voluntary liquidation, this type of situation very difficult.
I will go to the next.
Yes. Please continue.
It's a large case. Screen visible, sir, again?
Yes, sir. Yes, sir.
Yes,
Clear.
sir.
Yes, sir. This is a large case which was decided on 5th May 2026. Is the case of Ajit Kumar. It is a real estate company where he was an IRP. The show called. In this case, what has happened? The two disciplinary members gave different punishment, and then the matter was referred to the chairman IBBI, who confirmed one of the punishment. The two punishments were one was of 2 years and another was for 3 years. In this real estate case, I will summarize what he had given was he had given a contract to complete the process, and when the this Noida permission was not there, or Noida authority and the RERA permission was not there, he had given the contract to complete the construction work, where he says that he has given it for to complete the finishing type of work and no fresh construction. But the contract really meant that it is to be complete the process. And to the same contractor, ultimately the plan was given. Both were independent activity, but then he said the disciplinary order says that there is a bias in that. We'll go through that. And in every case, wherever the COC's permission is totally taken, it is not that the COC permission is not taken. And there are other issues also like information memorandum or full details and adequate presentation was not given, but he came out of it. That he said in a different manner that information was disclosed. See, the matter was referred to the disciplinary cover addition. Ajit Kumar doesn't seem to be bona fide violated of the independent, transparent, and building process. What he did was issue that with the contravention alleged that the show cause notice that Ajit Kumar granted pool and build scheme contract for completion of the pending contract. This was a large project at Noida of 17.5 acres of land and huge society. And mostly all the flat owners, the COC comprise of the flat owners only. Here, what has happened here, given the not issued the week and issued the work order on 19, despite the fact that necessary approval from Noida and UP RERA were pending. That was the one of the first default. He had given it to the Ecodel project, which was the consortium of the three companies. And he did not, in the same parties were given the project to which Mr. Ajikar that he did not inform about such conflict of interest to the COC. Since the Ajit Kumar as an RP being the chairman of COC, it was incumbent upon Ajit Kumar to clearly disclose the existence of such conflict of interest and its possible adverse impact on the transparency and competitiveness of the resolution process. To participate as a prospective resolution despite the fact that related consortium comprising of Nanu Govinda. See what has happened to he had given the contract to the same company and again the resolution plan of the same company was approved. To the participate as a prospective resolution applicant despite the fact that related consortium comprising of so and so has been awarded a construction contract of the corporator which compromise the transparency and competitiveness of the resolution process. Such an arrangement places other PRA at a disadvantage. Many times we see and the factories are given on running basis or production basis, and they themselves join as an resolution applicant, and their plan is also approved. So one will have to be very careful in doing this. I have seen myself the spinning mills, the entire spinning mill which was closed was given on hire to the some of the one of the applicant by proper bidding process, and then subsequently they themselves and the said party who was taken up the mill on the running basis or contract basis have been taken over by the resolution plan. This is somewhat similar cases. Only if you are doing that, then proper disclosure at each and every stage is very much important, because some of the other parties who are not or affected may go to the NCLAT or may go to the IBBI. Such conduct is inconsistent with the obligation imposed on this by ensuring that decisions are made without influence of any conflicting interest. Clause 14 requires that the insolvency professional must not conceal any material information of knowing and make misleading statement. In this present case, the Ajit Fair to explicitly identify, disclose, and appropriately mitigate the conflicting arising from the dual role of the concerned entity. Such omission not only erodes the stakeholder confidence but also impairs the credibility and sanctity of the conduct of the CRP by allowing a bidder to simultaneously act as a contractor without adequately evaluating and disclosing the attendant risk. Mr. Ajit Kumar failed to exercise the level of professional skepticism, care, and diligence expected of him. The commercial wisdom of the COC and alleged consent of the home buyer does not absolve the insolvency professional of his independent statutory duty to ensure fairness of transparency and absence absence of bias in the process. By giving that contract, he is effectively undermining the level playing field essentially for the transparent bidding process. Ajit Kumar argued that the decisions were based on the COC's commercial wisdom and home buyer's consent. As a resolution to professional who act as the chairman of the COC meeting, he is under a statutory duty to ensure full, fair, and timely disclosure of all material facts, including any potential conflict of interest. He cannot take a shelter behind the COC's approval when such approval was obtained without tracing complete and relevant information before it. The defense of reliance on the COC's commercial wisdom would have been tenable only if Mr. Ajit Kumar had made a proper and complete disclosure of potential conflict of interest before the COC, being fully informed and nevertheless chosen to proceed. In absence of such disclosure, the integrity and fairness of the process were seriously compromised, attributing to the resolution process failure to discharge its statutory duty of full fair and timely disclosure. Ultimately, the chairman of the IBBI went before the 3 years of suspension.
Ravinji, I have a couple of things to share here. No doubt,
Yes.
we should be talking about disclosure and transparency. That is of utmost importance, and everything must be informed to the COC from time to time in the COC meetings before any action is taken, not after. So that is no doubt about it, and that cannot be doubted at all. One question comes to my mind always is, in many of these orders, only one party, that is the RP, is a party. However, nothing stops IBBI from calling other parties as giving some more evidence or not, like whether COC was informed or not. There are certain documents which the RP might have placed. However, whether COC was really informed or not, and whether COC was compelled to take this decision because of non-information, that kind of an evidence could have come from COC also. COC might have supported, might not have supported the RP. But without talking to COC, saying that COC is discomforted or put at disadvantage, or even the other competitors are also put at a disadvantage, these conclusions could have been taken after taking some kind of evidence from these parties. I'm not saying that the order is wrong or something like that, but something more, because you are punishing an RP for certain things without hearing those parties out. So some evidence, some kind of an information can be sought, according to me. Maybe IBBI may or may not do that, but at least RP who represented there could have done something like that to support his case. I am not saying his case is right or wrong, but that can be taken that if there are allegations by any party outside, if COC is there to support, if COC says I was informed, this was the best possible resolution applicant, etc., that might have helped the RP to present his case in a better manner. So that is my only submission for consideration. Of course, recording that you have put it before the COC, COC has considered it. Disclosures have been done, must have been recorded properly. That as the order says, is not seen. But this is my view, sir, in general. Thank you.
So,
Many
Vijay,
times it happens. Sorry.
what I was thinking, can a RP in such case when there is a DC and he is going for a hearing, let's say, so can the RP actually request a COC member to appear along with him?
No, sir,
ऐसा
that
The
kind of
argument
appearance is not possible because even getting a counsel on board is difficult many a times. I have helped many people in appearance before DC in securing a suitable counsel, etc. So suitable counsel is allowed. Counsel is allowed to argue also if appropriate process is followed. However, while the submission is to be made by the RP, I think at that time RP can think aloud, go beyond. If RP says COC is not put at disadvantage, why not to go to COC at that point itself and get some kind of an support if it is available? That yes, we were not discomforted, we were allowed, we were having knowledge of that, though the minutes do not capture it in that manner. If that kind of evidence exists, why not to bring it on record while the documents are being submitted? That is my submission.
No, I was coming from a different point, sir. Can it be compelled by an RP on basis of principle of natural justice that the COC, if they're alleging that you have not informed this to COC, that all this thing, a representation of COC also be there before the DC to either support or this thing if the COC says कि नहीं, we were not aware of it. So yeah, 3 years, yeah, 5 years, permanent deregistration, all that is there. But if the COC comes around and says, because here, since this guy gave this project on to a contractor, I am assuming that the COC would have had a role in determining whom this project was given.
Yes, yes.
Without
That is
all
not
that
discussed
was
here in the
done.
order.
All that was done. Each and every contract was discussed. We will take it forward. It is there. That entire discussion was there. COC's permission is there. Debate is
then,
there. They
then well,
appointed a
No, no.
committee. All that steps
May
have
I
been
clarify on this? I do have a little idea of this particular case. Okay, and also the general principle. The first thing to remember in the principle is if it is not written down, it did not happen. Oral evidence not backed by written evidence by way of minutes, specifically, is not considered in IBC. This is a IBBI order going back to the early years, I think 2018. Okay, when somebody was appointed as a valuer or forensic auditor, I don't remember which, by consultation with one COC member who held 90% vote share. So IBBI in that
PNB was
said,
involved in that. Yes, PNB was
yeah,
involved in that case. Yeah.
yes, and IBBI in that very clearly said, even if there is only one COC member, it has to be through the process of a meeting. There is no waiver for it. You have to call a meeting, even if it is a single COC member. You cannot have, for example, if there is one member, you technically you don't need to have a meeting. You can exchange, correspondence through email and arrive at a decision. Not allowed. Okay. The process says this is the way to do. So there is a binding series of binding judgments of higher courts, including Supreme Court. That procedural law has to be followed to the T. There is no waiver. Okay. If something is said to be done in a particular manner, it has to be done. So the question of whether RP had a defense, it was not recorded. That's all that is. Okay. Now, what is the real allegation? That's important. So there are two separate issues going on here. One, appointing a consortium as a contractor. Another is examination of resolution plan received from various people. Now, the commonality of one person between the two is something which has to be, which obviously the RP knew, and he has to bring it to the knowledge of the COC. This is it. Specifically, it is okay. You cannot assume that I have given you the information. It is there. There is somebody was once telling me, VDR में तो डाल दिया है. You should read. No. If something has to be put explicitly, it has to be done. That is the problem in this case. That the apparently conclusion was that this seems to be a way of trying to get away with it by trying to keep two compartments separate, some sort of a Chinese wall. That is not allowed. That is what this entire order is about. That yes, you put both pieces of information to the COC on different occasions for different purposes, but you did not tell the common thread joining the two. That is the problem.
No, I will try to
But in this
differentiate
case, the
this
entire
little
contract was
further.
discussed and everything was given to the COC, and
No, no,
COC
no. I am
approved
telling
that.
you, sorry. See, please understand what I am trying to say. Yes, the information was there, but the line joining them, what IBB is telling, that is the RP's job. It is not the COC's job to find out the connections. You knew it, you place it. That's all. What is so troublesome about telling it?
I
The
will I will add something here to both Pravinji and Raviji. Yes, the link should be explained, no doubt about it. However, the conclusion that COC was not aware could have been at least tackled by bringing some kind of document from the COC to. I'm not saying this what
No,
was
it was
followed
not
was
there.
right.
Udayji,
Uh,
it was not.
uh,
It was not there because he has admitted I did not tell them.
okay, okay.
Ah,
Then-
he admitted it is part of the order.
okay. And
But,
I'm just talking in common parallels that in such
but
Yeah,
sir,
situation,
of
if
course.
Sir,
you're
Gandhi
trying
sir,
to get
if
out of
even
a
if
well, then this such kind of evidence, if it exists, can be
Of
shown.
course, of course.
Nothing. Yeah,
sir,
Yes, yes.
nothing.
I mean,
so what
even if it is by way of a common email sent to all of them that is there,
Yes, something.
it
Then
could
it
have
can be brought
helped.
on record. Nothing
Yes.
more than that. But that doesn't absolve the RP from the process that he didn't follow. No.
see sometimes what happens, sir, RP may not have recorded in the meeting in minutes as procedurally there's a lapse. However, the decisions taken by the COC, I think where I'm coming from is that could actually be taking into cognizance this particular information. So calling COC and asking whether they were cognizant about this is also relevant fact as regards to the order
No,
part.
no,
So,
it's
so,
not. It's not.
so
If the RP had actually, intimated and it is only a lapse in recording it, he could have as well. Okay,
Yeah.
ask sent a mail to the COC, please confirm that this was discussed on so and so meeting
Yes, yes.
and
And
it's
even you have
here.
video recording
And
also with you.
if they would have replied, yes, yes, we are aware of it, that would have sufficed. But you're missing the one statement here. RP said, I did not inform them. Over, no matter.
no, no, I agree. No, no, I'm Ganti sir, two things. I think I'm asking, I'm not about this specific order. RP said I have not informed. Period. No discussions on that. Okay, he has failed on it. What I'm only saying is, as you rightly said, it is in the VDR, it is in some place. The decision-making body, which is in this case probably the COC or any COC, if they have evaluated by themselves, RP did not inform, I accept that. They have themselves evaluated and they have come to a conclusion, whatever decision they have taken based on their own assessment of that entire information placed by RP. That is a sufficient evidence that there was no wrong done to them because they were cognizant of it. It's a procedural lapse by RP not to inform. I'm trying to distinguish that part of it.
Yes, yes. No,
They,
Ganesh,
they,
that is
all
what I
that
was
is
trying to
fine.
say.
All that is fine. All that their disciplinary proceeding may. There is no, what do you call, provision for having witnesses. It's not a trial. It's never allowed. Okay. In these cases. So, but you can get it through documentary evidence. So
which is
are
what Udayji is saying, na?
no
If COC is
the
called, it
COC
helps them.
no. That is trial. You RP, if I want COC to back up something which I have done, which is not properly recorded or whatever, lapse. When the show cause notice is issued, even then I can ask them,
Yeah,
no,
that time
please
you can ask.
confirm.
Which
Yeah.
I'm with you. That's all I'm saying. They should
Okay.
see, because in one of the cases which I know, there was again something about RP, and then COC actually tried to give all the evidence also, saying that, hey, listen, we have accepted so on and so forth. But irrespective of that, eventually there was an order passed. So I was just saying that from what Udayra say, I said probably if I could classify the three parts of it. One, RP did a procedural lapse, no wrong done to anyone. Second, RP did a procedural lapse and wrong is done. Third, RP did procedural lapse with an intent to commit fraud. And fourth, the fraud is done. So if I were to classify, then the orders could be based on that, the proportionate impact.
That is, you're right, and that depends on the matter at hand. Here,
Yeah.
what is the allegation? That the level playing field has been disturbed. Was the waiver given consciously by the COC in exercise of its commercial wisdom? It is not a question of oversight. मैं type करना भूल गया. I ran out of ink. चलबे ना. Okay, this had to be explicit, separate. In fact, it should have been a separate item of discussion in a COC meeting. Conflict of interest and whether there should be a waiver.
Now I will add something here. Even in this case, COC is not consisting of any institutional creditors.
Yes.
As I read, it
No.
is only the flat owners. So
Home
even in
buyers.
such cases, the disciplinary committee or any other authority looks at the quote unquote commercial wisdom thing. Actions by the COC are taken with a pinch of salt, and that has been observed that if the financial institutions who are regulated are not part of the COC, then the decisions are checked again and again, and they always check whether they are kind of influenced or misguided, and are they again quote unquote innocent decisions. So these things are looked into. Yes.
100%, absolutely. I mean, that is possibly the most important point. When it is only allotted as COC, it is the threshold of disclosure and is much higher.
And
Incidentally,
again,
the
as they
recent
say,
amendment brought that, sir. If you see the recent amendment, if it is
yes, yes,
not a
yes,
financial institution
yes, yes, yes.
or a public financial, additional stuff what RP is supposed to do will
Yes.
be provided.
Majority
Yes.
decision cannot make something which is illegal as legal.
Yes.
Here again, the Flat Owners Welfare Association and some here again the Flat Owner Welfare Association and some home buyers filed various complaints.
Sir,
One
echo
second,
is
one
coming,
second.
sir.
Mr. Avinash Tripathi, please mute yourself. Yeah.
Laid certain concerns alleged misconduct of Ajit Kumar. These are home buyers which had taken the drag this case association. So wherever these home buyer associations are there, one has to be very careful. See that all queries are answered or they have been whatever open house or the AR is supporting them because they are prone to complaint and they are advised to complain and that leads to all problem. Here, what has happened is lease deed was by the Noida in favor of the further Noida had later had approved the building plan. The wherever the government authority is the landowner, they try to create their problems, and we have to take them into consideration. See here again, the Ajit Kumar had failed to upload the project details on the RERA website. Thereafter, assuming that the charge Ajit Kumar issued a notice from RERA on so and so date intimating RERA registration from said project has been expired. So Ajit Kumar submitted that due to unavailability of login details from the suspected that he could not upload the details of the project on the RERA, but that will not act as an excuse. He had filed a 19(2) application for the seeking detail. Ajit Kumar also failed to execute a registered sale deed for the completed apartment due to non-issuance of no objection certificate by the Noida. Now, this real estate, and I have not handled, but those who have handled, that completed flat needs to be given, sale deed needs to be registered. Due to that, all process need to be done. And this is another issue. While the approval from Noida and RERA were not yet received, Ajit Kumar executed a construction contract with the Nanuram Oil and Ecotel. See, and then when the RERA objected sealed the project, he went to the High Court with a writ petition. Ajit Kumar, here the board says he had contributed the provision of 1728, compliance with the all laws. That was breached. This taking the that partially constructed commercial area at the location not approved by road, thereby necessitating revalidation of the layout plan. Then when the matter was sealed, then he approached in the capacity of the RP, he approached the Honorable Hyderabad High Court seeking direction to the Noida for revalidation of layout plan as unable to enable to extension. See, originally the RERA permission was obtained, but subsequently the extension it expired the period. So when it was not granted, he went to the High Court by writ petition. He approached the High Court, sorry, not writ petition. The sealing orders were issued by Noida, were set aside by the Honorable Allahabad High Court in writ petition number so and so. Why did order dated so and so, thereby validating the RP's action. He also argued that the permission, RERA permission is only required when you do additional construction or change in this structure or anything. He said that the only renovation or redevelopment activity that do not involve marketing or selling. He also argued that the RP emphasizes that the importance of uninterrupted continuation of the operation, especially to safeguard the interests of the home buyers and protect project at value site. The DC further noted that harmonious reading of the Honorable High Court order dated so and so and Noida authority later dated so and so does not support the interpretation that authorities approved the action undertaken by the Ajit Kumar. See, High Court had allowed him, but that doesn't mean that the order is approved. Then he said that only the finishing work was given, but as per the contract, it was clear from the above scope of work, the construction contract for the construction of residential tower in all respect, including the civil structure work. Further, the activities undertaken by Ajit Kumar were violative of the Honorable High Court or Allahabad High Court or direction where order dated so and so in respect of so and so order. And here it was further observed that Ajit Kumar had charged an additional amount of rupees 150 per square feet as an interest fee interim finance for the from the allottees. Further, the payment structure to be contracted at envisaged, Ajit Kumar depends on the obtaining 25,000 from every allotted home buyers as token amount for their respective flat with their consent. See, there was an increase in cost and the finance cost. That's why they raised the amount also. It was alleged that the show cause that Ajit Kumar deviated from the terms of builders buyers agreement and also failed to hire a construction contractor who would include all the essential items required under the builder. Some of the items he excluded while constructing. So they said that all the items were not included. Which Ajit Kumar replied that whatever was essential he started with. Actually, all these should have been properly recorded or he should have done. I think at all places is not wrong. Whatever was feasible at that time, he had taken the steps to do it. And Ajit Kumar submitted that consent was duly discussed by the home buyers and the 5 members project monitoring committee constituted by the COC. In this case, the whatever the monitoring committee was constituted, their minutes also should have been recorded. He had raised the interest-free interim finance was specially approved by the COC. Importantly, home buyers are not incurring any cost beyond this contemplated in their respective builders buyer agreement. He had raised 150 rupees per square feet toward the additional interim finance. And there was specific condition that interim finance would be raised only when 85% tower-wise participation is achieved. Otherwise, that interim finance would have been not been of help to him. And he has given the reason also that interim finance was raised because the GST was applicable, collectible at some 12% and payable at 18%, and this created a mismatch in cost with the no additional burden on the home buyer. The DC notes that the situation where the corporate debtor is undergoing insolvency, the fund available to meet the past commitment are going to be inadequate. In such a situation, it is not possible to carry out the commitment in entirely as promised by the ex-management because of the lack of fund. Therefore, the stakeholders have to decide what needs to be prioritized within the available fund. In this case, the DC find that the matter has been discussed several times by the stakeholder and they have decided to by substantial voting share about them item which need to be prioritized and how the fund to be same be arranged. The funding of this prioritized work has been envisaged within the scheme of the court by treating them as an interim finance. In view of the above, DC accept the submission by the Ajit Kumar. See, wherever recording has been done properly and whatever has been prioritized, some of the items which he excluded in the contract, so this is accepted. The non-disclosure on information memorandum, what is the observed that whatever the items were not disclosed, total area under Lotus Zinc project, number of units of Lotus Zinc project already completed and handed over, not non-approval of the building layout by Noida and the non-compliance under RERA Act, the fact that construction of lift as well as DG set STP form part of the budget for the construction contract instead of showing it as a list of items that are excluded from the construction contract. and the details of unsold inventory lying on the site. These are the items which he said it was said that he has not disclosed, but ultimately it was explained to the DC that it has been disclosed in the various forms. In different forms, there it has been disclosed. The things it should have been disclosed, the important facts would have been disclosed at one place or properly in the information memorandum. The learning I felt was that wherever this information memorandum it should be disclosed at one place. Secondly, at times we give a lot of information in the way of the VDR. Whatever you have disclosed in VDR, the copy of that should be properly kept in the office in our hard disk. Because VDR is for the time being. By the time you get the disciplinary order, disciplinary show cause notice and other thing, the VDR would have been already terminated. Here he explained that these all things were given in a various form. Like he said, the total land area was disclosure made by Ajit Kumar in different places. Page 33 of the idea, the total thing is spread over 17.4 acres of the number of units. Page 34 to 27, he has disclosed this. This all disclosure he had made in the various proofs, so he could prove it and that was accepted. On pursuit of I am an additional submission of Ajit Kumar, the DC is satisfied that the material disclosure required under the Regulation 36(2) of the CRP regulation were compiled by Ajit Kumar. The disclosure through some spread across IM pages, annexure in VDR were adequate to inform PRA of the true state of affair, except the details of material lying on site as, as has been dealt in the next conservation. There was material lying in the site which ultimately he sold it with the permission of the COC, but that was not disclosed in the IM. The material lying at the site, there is a reasoning he says that was getting rustated due to being kept in the open area and was also occupying the basement car parking. In addition, Ajit Kumar informed the COC that material posed a risk to the lives of the resident and hence suggested the scrap material may be sold further. The Ajit Kumar failed to inform the COC about the proceed collected from the sale of material lying on the project site. So and so, the code requires resolution professional to preserve and protect the assets of the competitor. See, he has taken the permission and sold it. But then of the money, what he did of money has not been stated. But it could have been showed that this is received in the bank account of the CRP or the corporate debtor and the way it has been used or whether it is being used for CRP cost or any other cost or for the project. The record stood at 8.5 crore, was approximately accounted for in the resolution plan. He cited that enclad in Jet Airways Maintenance Engineer Welfare Association that herein it held that the RP is authorized to sell unencumbered asset during the CRP if it is help in value realization. But here in this case, building material was not a fixed asset. Here he is properly informed, but what he did about the money, that only he is not informed. He did boundary wall construction also. The DC further noted that Ajit Kumar White email dated so-and-so had shared the report of auction of scrap received by him from the e-auction platform to the AR, and the AR White email dated so-and-so acknowledged that Ajit Kumar had shared the given information with the home buyer. It is not that he has done something wrong here. However, it was not disclosed by him in the updated information memorandum prepared by him on so and so date. Further, DC is not in agreement with the explanation of this that since scrap has already been charged off in the book. One of the explanation is that it was already charged in the book. He has not disclosed in information, but that ground is not accepted. Here, the issue of work order to Ecodel at the time of submission. The consortium of Ecodel was also one of the resolution applicant. Plan which was approved scored 60% on the evaluation matrix and compared to 52 marks by Abhishek, the other party. Allowing the same entity to be the prospective resolution applicant would be prejudicial to the transparency and competitiveness of the resolution bidding process. Such an entity would be having an obvious upper hand and will be in an advantageous position as compared to other PRAs. Therefore, there is a need for greater scrutiny and evaluation caution while considering the resolution plan. What he should have done, he should have properly disclosed the interest to the conflict of interest, whatever he should have put it before the COC members that there is the same party, whatever the connection is there, that's all. And one of the party did not withdraw from the submission of the resolution plan. You observe that allegation that allowing a withdrawal of the plan without forfeiture of the EMD was not dealt. I am view that the same may be investigated as how the plan was permitted to be withdrawn without forfeiture of EMD. In fact, it appears from the record that EMD was furnished by Pragati Group in form of check and not in form of the demand draft. This is also important that only he had taken a EMD in a form of check only. Was furnished by Pragati Group in form of check and not in form of the demand draft as stipulated by RFRP. If this was the case, it must be examined whether it was correct on the part of Ajit Kumar to present the resolution plan before the COC and open it for discussion even when the resolution plan was probably not in accordance with the terms of the RFRP. In effect, the withdrawal of the resolution plan by Pragati Group is not absolutely explained from the facts available on the record. This will be the other matter. I think this is the crux, and ultimately the 3 years suspension was confirmed. Any question or we can take one more case.
See, one question, and because already at 8:50, sir, Praveen sir, I don't think we have time for another case. I One is, say in real estate project, you are saying that if the resources are not there inside the system, um, oh, you will have to run it and according to you, we have to register it. So you need some subject matter experts who does day-to-day such kind of a transactions.
Yes.
So searching for them, because one of the easier way for someone to search is if they are part of an IP and if the IP has an ecosystem, hypothetically. But the current amendment says regulation, there's a, in the February 2025 or May 25, it says that you cannot hire a person from your own IP.
Okay.
Now, the question is here, the duty is to ensure that, if the resources are not there in the corporate data or someone you cannot trust, even if there are resources, you may not be in a position to trust them. Ideally, RP wants to hire someone neutrally so that he doesn't get faulted later. But the regulations prohibit RP to hire
Mm.
related
From
party, I
his.
understand. Not
Mm.
that's the, even the IP through which he actually is a director, he says that you cannot hire. Is it not a blanket ban? Because the IP means at least there is a trust factor for RP. Okay, something nothing will go wrong. And scouting from the external sources that could only delay and that could have challenges. So I was just trying to link up the responsibility that you laid on here in terms of the resource requirement to
Yes.
do the duties of RP.
Yes. Second thing, many times the COC doesn't approve the budget. So they are so much they have lost in this project. If it is in this case, it was home buyer, so there was a different approach. But if the banks are there, institution is there, they normally don't approve any additional cost.
Yeah, agreed.
Udayraj was here for his handling Lavasa. You could have got the information about the same.
No, sir, I
Please.
can just add something here uh, about the views put up by Ganeshji. So yes, IPE, the directors cannot be hired, but IPE can still be appointed. So if you want one of the directors of IPE to help, you can appoint the IPE to assist you. That is very much legally possible, and that is the only way out here. Otherwise, getting a director from your own IPE to assist you without the IPE being appointed as an additional entity is not possible. First thing. If the work is given to IPE itself, and you have done a cost cutting by undercutting or something like that, then God will help you. Because if you are coming in as an IPE saying that I am a bigger institution, and if there is a fees of 3 lakh rupees to be paid otherwise, and you get the work at 250, and then complain that I need more people, then I don't think there is any possibility of helping this person out. These are the two issues that I would want to put up here. Otherwise, getting an external consultant, getting a CEO from the company, getting an architect appointed, getting an PMC appointed, I don't think there are any issues in that. That
No,
can
no.
happen anytime.
Okay, first of all, if someone has the intent of doing wrong, I have no sympathy for that person. Anyways, so that's outside the scope for me. Where I'm coming from is this earlier, the regulation 27 of CRP said appointment of registered valuers specifically. And in the registered valuers, we have a categorically saying that it is not the related party, not the auditor, so on and so forth. Now they have modified the title as appointment of professionals. What appointment of professionals in the CRP is there is not the same as appointment of professionals in liquidation. The requirements in CRP are more stringent, which also says that you have to exclude appointment of a director or partner of an IPE in which you are also a director or a partner. The question is, what I understood you are saying is ki, give appointment letter to the IPE and use the director to run. So so that doesn't really give me an. I mean, it is there. It's a
So there is
circumventing
the
the
only
same thing.
solution. I don't think this
No,
can be debated further. There is no other option.
no. Why I'm coming from is if you see only if RP believes that there are no such resources in the corporate data. I'm just trying to bring that caveat here.
Then,
If it,
then, then we better is to hire an employee in the company who will be able to perform various jobs. Like people always say that the RP is a CEO, which I differ. IP is not a CEO. IP is in sitting in the place of board of directors. If you need a CEO to run the company, get a CEO. If you need a CFO to run the company, get a CFO. If you need a chief project manager to run the company, get a chief project manager. So, though everybody likes you to be called a CEO, practically you are not the CEO. You are only the board of directors. So, if you need experts to run the company, please hire them. That is what I am trying to suggest here.
Certainly, yes, sir. With due respect, I thought COC is the board of directors, RP is the CEO. Probably I take it your perspective. I actually thought the other way around. COC is actually the board of directors. RP is the
No, sir,
CEO.
law doesn't say that. Law says that the board of directors is suspended and the rights are invested in the RP. So practically people think the RP is the CEO, but law doesn't say so. So I also didn't so because I don't have the capability of being the CEO. I can be the board, I can give direction to the company with the permission of the COC. But if you need a business expert who can run the business, get that person. That is what I'm trying to say.
So we conclude here or we take one more case?
So one more case, how long it will
We
take?
generally stop at 9, sir. 9
Yeah, that is
because
the correct. That's
yeah.
correct.
Okay.
So
So
let's
in
maintain
general,
that.
any other topic or any discussion or anything or about the next meeting?
So we'll discuss, sir. Maybe CRP,
Okay.
recent amendments, no? Even recent regulations are notified recently.
Sir, now appeal has been allowed against the DC orders to NCLAT, and that is going to open up a new era of disciplinary orders being revisited by an judiciary. So High Court had a different view. High Court kept its hands away in most of the cases, saying that the actions will be taken by IBBI and we are not going to look into that. However, I have a feeling that IBBI's action also can be scrutinized, whether they were right, wrong, whatever we discussed. Judicial scrutiny of those orders now will be possible, which was not possible in the past. So if we want to take up that topic for some time by any of our members throwing light on the possible angle that NCLAT may have in those orders, to which extent they may go, to which extent they may not go, I think that can be also discussed for some time.
There is a precedence of that in terms of labor matters, where they go to High Court. Okay, and in at least in Bombay High Court, there are two benches who deal every day with such matters, and half of the time is only on this wrongful removal, wrongful termination, promotion not given, etc., etc. So there is a precedence for disciplinary orders being adjudicated by courts. Since there was no exclusive provision, now that has come. This is NCLAT being the appeal body for DC orders is, I think, of the ILC Committee 2022 report.
Yes.
4 years later, it is being implemented.
Yes.
I think probably Navendra sir, you are saying, I think Nodaya sir, whatever he stated, that is something, if any member is interested, we should take up. And probably the kind of amendments that are happening every other day, suddenly when you wake up with a new amendment coming up in regulations, we can actually have more like a compare and contrast with what we were doing for the years now. Suddenly the new changes, maybe we can have more like a compare and contrast rather than just reading the amendment. So that way speaking, at least our mind will shift to a new way of looking at the regulations. That is something, sir, Harish sir, we can take up. Any, I think, speaker we can bring in, and apart from the speaker, each member here has capability. They can also present the view, and we could have good discussions on that, so that most of the members can be abreast with it.
Yes, sir. Yes. And
Thanks
also,
for the opportunity.
many members now DC cases approaching High Court. Let us see anybody approach NCLAT also, and also what are the pending recent DC cases, sir? Will you also take after next session, sir? Maybe in the month of August, one more time, we'll have the DC matter, sir.
Done,
Praveen,
sir.
sir. Okay. Any more
Now,
questions, speaker? So you can stop sharing, sir. Everybody can on their camera and interact with them.
Yes. Any other point?
we can call it a day.
Okay, sir.
Thank you, Pravinji, for sharing
Yes,
Thank you, sir.
thanks
Praveen, sir,
everyone.
for the
cases.
detailed explanation of the DC cases.
Thank you, Pravanji. Thank you, everyone.
Thank you, all
Thanks,
participants.
thanks
Thank you,
all
sir.
participants.
Thank you, Praveen, sir.